Good evening and welcome to the February 22nd meeting of the Civil Service Commission. May we have roll call, please?
Commissioner Manukian.
Here.
Kazarian.
Here.
Gregorian.
Here.
And Devine.
Here. What is next?
Minutes.
Okay, do we have a motion for approval of the minutes?
Move to approve. Second.
Second. Any objections? Have unanimous consent. What I want to do right now is pull one of our items out of order. We have the police chief and the police captain here, and so I want to take this item as item number 6. So, Mr. Doyle, would you please read that?
Okay. Report on administrative leave.
Mr. Chair, members of the Commission, this item is a report which you had asked me to prepare last month. This came about from our January 11th meeting of this year, and the report seeks to address some concerns that were raised about our use of paid administrative leave in various situations. I had intended for this report to be brief, but as I got into the discussion of this issue, I found that was largely difficult. And there are just a lot of issues relating to this topic that I think answer the question as to, why we need administrative leave and why it tends to go on for so long. Again, this was an item raised by Commissioner Kazarian, and part of the concerns related to really the length, the duration of this leave. Is it appropriate? Is it fair to the taxpayers to have city employees on paid leave, essentially sitting at home earning a paycheck? And whether or not I think there should be some role for the Commission to play in either looking at administrative leave or extending them. Now, what I'd like to do is kind of go through the report, and again, if you'd like to interrupt me, ask questions, feel free, but I'm more or less going to follow along. And I have cited in the report the authority for granting paid administrative leave, and that's found in Rule 10, Section 3. And really there are three primary circumstances when administrative leave is called for. The first being if we have some form of a investigation involving either serious discipline or anticipated discipline that might be resulting in a termination or dismissal of an employee. The second circumstance under the rules talks about if an employee is charged or indicted with a criminal offense, and while those charges are being kicked around, the whole notion that an individual is innocent until proven guilty, you want to have them away from the workplace, yet they haven't been charged with anything or convicted of anything. That's a very rare circumstance. In fact, I don't recall this occurring much at all throughout the course of my career. The third circumstance is where you have a ordered medical or psychiatric or psychological appointment for an employee, where you're trying to determine whether or not they're essentially fit for duty. And that occurs occasionally. But by and large, the most prevalent circumstance when employees are placed on paid administrative leave relates to the first circumstance where we're talking about either investigation of a discipline or the decision has been made to impose discipline on a particular individual. And that's really what the report focuses on primarily. So I'll start with that part of it and more or less why we do it. And again, in those circumstances when we're talking about either an investigation or discipline, there are certainly circumstances where it is appropriate to remove an employee from the workplace. If we're talking about some type of a disciplinary situation and something that needs to be investigated, there's always the concern that if the subject of that investigation is in the workplace, there could be a circumstance where they might either be disruptive to that investigation, they might threaten, intimidate, or even retaliate against potential witnesses, and it's prudent in some circumstances to make sure that they're removed from the workplace at that point. And the report addresses some extreme circumstances where you have a situation involving either really egregious conduct, such as sexual harassment or violence in the workplace, where we could be exposing ourselves to some liability if we keep an individual accused of those things in the workplace.
If I may,
Sir.
with your permission, interrupt you for a moment. First, let me recognize the chief who is present here, and Captain Stokes, and I thank you for being here because I asked for this report.
Sir, may I also recognize Ms. Beers, who's Yasmin Beers, our Assistant City Manager.
Though I know the name, I did not know the face. Welcome. Welcome all.
She's a player in this
Very well.
whole process as well.
Fire chief is
Who's hiding back there?
our fire chief.
Oh, the fire chief. Okay. Hello. Hello, everyone. When you have listed under Section 3, subsection A1, what essentially is a recitation of Rule 10, correct?
Yes.
And it says when an employee is under investigation by the city for accusations made against them or on proposed disciplinary action, and in the judgment of the department head, forgive me, who would be the department head? Would it be the chief or the actual unit head?
Mr. Gazarian, that would be the chief.
The
That
chief.
would be
Okay.
the executive in charge of that particular department.
Okay. And with respect to paragraph 2 in the following page, I don't have any question, but when I look at paragraph 3, the question I have is when it says when an employee has been ordered or is awaiting findings from an ordered medical psychological evaluation to determine fitness for work, the ordered medical psychological evaluation is ordered by whom are we referring? Again, by the chief, or are we?
Yes, sir. The department head. And-
Okay.
And
So, forgive me. Go ahead.
I was just saying, and usually that's a case of either the workplace safety, the employee may have a physical injury for which we're not certain that they're fit to work, and before we allow them to return to work, we would set up some type of an appointment to have them evaluated. And it also leaves open the situation of a psychological evaluation as well, if that happens to be the injury at hand.
Okay. And as to 1, 2, and 3, City Hall or City Management or Ms. Beers, I take it, do not play a role in these steps 1, 2, or 3. Whether it's a determination that somebody's charged with a crime, or whether it's a matter of someone perhaps needs to be evaluated, or someone needs to be removed from the workplace so that they do not potentially, if not actually, obstruct.
Commissioner Gazarian, I would say Ms. Beers would probably not play a role at that point. There may be an awareness or an acknowledgement or an FYI type of thing, but if we're talking about a case that may result in proposed disciplinary action later on, Ms. Beers and her staff try to stay as much out of the details of that case because they do play a role in the predetermination hearing process.
Skelly Pass?
Correct.
Okay. And as to 1, 2, and 3, I presume, and correct me if I'm wrong, the person or persons who are placed on leave, perhaps in a similar fashion to those who are accused of crimes in courts of law, they are given a notice of the charges against them, or are there circumstances where they are not given notice of the charges or the reasons for being placed on leave for fear that they may, in fact, interfere with ongoing investigation? Is there any distinction between giving a notice or not giving a notice that you know of?
If we're talking about, subsection 1, if there's a disciplinary type case, typically they are given a general idea of what the leave is for, and there may be even more stringent requirements in that regard when we're talking about a public safety officer, particularly when an investigation is commencing under POBAR and now have the Firefighter Bill of Rights. You do have to provide some level of information on that once the investigation commences.
Yeah, other than subsection 1, I mean subsection 2, if somebody's charged with a criminal offense, they are on notice of that, obviously, and,
Yes.
and if they're sent for any kind of an evaluation, they too have to participate in that, so I would imagine they would be on notice. Very well, I'm satisfied. Thank you.
Yeah, and I'm sorry, just a clarification. I think some of the issues that I think, at least for me, I used to get them mixed up, is I think a lot of these situations, what happens is they're actually investigating to see if, in fact, a crime took place. Is that correct? I see. And I think it's a little bit different from each department, because when you have, as you said, issues of ProBar or the firefighters, then you automatically fall into a different set of guidelines that you have to give for them their rights.
Yes, sir.
Under there.
They're similar, but just a little more stringent when it comes to dealing with a public safety officer, whether it's a sworn police officer or sworn firefighter.
And just a note on those two items, and it's not something that we would get into today, but I think it would be helpful for us in the future if we can get a presentation on exactly what POBAR is, what the fire, because that helps us understand, even though we've come across it during our hearings, but I think to understand a little bit the history of how the Police Officer Bill of Rights came into play, how they're different from one another. I just recently found out, for example, the firefighters is a different, so I would, again, whenever later on, I don't know how my commissioners
Okay,
feel.
I think both the commissioners have excellent points and excellent questions, and you bring up a good point, Commissioner Manoukian. However, I think at this point, I'd like to see Mr. Doyle complete his report.
Sure.
And then we'll hold our questions till the end, because he might answer some of them as he goes along.
Absolutely.
So I think we'll let Mr. Doyle continue, and then we'll certainly open it up for questions. And we do have the chief here and Captain Stokes, so they'll be able to fill in, and of course, Ms. Beers. So, Mr. Doyle, please continue.
Okay. I was talking about why we would place an employee on administrative leave in these circumstances, and I discussed the investigation process. The other half of that would be when a decision is ultimately made to propose termination for an employee. In probably 99% of the cases, we will then either have that employee continue to be on paid administrative leave or put them on paid administrative leave. And there are a whole variety of reasons why you would not want an employee who is about to be terminated to remain in the workplace. The report addresses various circumstances, their ability to disrupt the anxiety that they may cause to other coworkers, potential sabotage, potential the destruction of city supplies, equipment theft, even the filing of a false workers' compensation claim, things like that. So again, when an employee is being terminated and an employee is served with a Skelly letter for termination, in most cases we will have them retained on administrative leave with pay. The next part of the report addresses the whole issue of why is administrative leave provided with pay, and the question comes up, and it's often asked, why are we doing this? If somebody has presumably done something wrong, why do we reward them with a free vacation? And the simple answer is it's again the whole notion that one is innocent until proven guilty, and until all the charges have been brought forth, proven, and imposed upon the individual, you really cannot place anyone on a unpaid leave because it essentially deprives them of a property interest right. And again, I think you all know under the disciplinary process, the Skelly due process, any type of property interest right that an employee is deprived of, they have to be given a full due process, and that means essentially that they are continued to be on a paid status until the final resolution of that case at the predetermination hearing phase. I do address in that particular section of the report that an individual who is placed on administrative leave is actually still employed by the city. They're capable of doing work, and they can be assigned work. Typically, they get assigned to work out of their home. They have to remain home during that paid administrative leave. But if there's any type of assignment that could afford itself to being done at home, whether it's a report, a performance evaluation, or some type of special project or an engineering project or something like that, it certainly can be assigned, and some productive work might be done. Obviously, this individual does need to stay in contact with their supervisor. Supervisor, has every right in the world to call and ask them questions. Hey, what did you do with this project, or where's this assignment, or whatever the case may be. So, the whole notion that the individual is sitting at home, enjoying themselves is not necessarily a logical conclusion in every case. The next part of the report addresses the duration of administrative leave, and I think a lot of good discussion, rightfully so, on just the question of why does this take so darn long, and why are people who are placed on administrative leave off for so long. And again, a good portion of this report seeks to answer that question. And as you'll see from all of the various processes that go into not only the investigation, the preparation of a case, the completion of a Skelly letter, the predetermination hearing process, you'll see that it's very easy for this process to get bogged down and to drag on for weeks on end, sometimes month after month after month. So this part of the report, I do kind of take it as a step-by-step process, and I want to start with more or less when a supervisor is put on notice of potential misconduct. And obviously, I think you all know that when the organization or any of its managers or supervisors are put on notice, we have an obligation to act. We have an obligation to address the issue, whether that means sitting down with the individual who's being charged, or conducting some type of an investigation, whether it's just a general administrative investigation, whether it's an internal affairs investigation conducted within the police department. It is a process that has to take effect, and it is something that is quite laborious. And I know all the commissioners have seen administrative investigations in the various cases that you've heard before you, and you can generally tell a good investigation from a bad one. And an investigation has to be done with individuals who are specially trained for that and specially prepared for it. It's not the type of thing that you can just sit down, have a discussion with an employee, and draw some conclusions from that. Typically, you have to advise the employee of their rights. You have to prepare questions. You have to look at the allegations. You have to advise them of their rights to representation, and there are a whole set of things that have to be factored into before you even sit down with someone to begin the questioning. And again, there's identification of who the claimant is, identification of who the potential subject is. You have to consider all the witnesses that you need to talk to, and it's inevitable, because I've done investigations, and anyone who's ever done them, you'll find that something that starts out looking like a very minor thing sometimes branches out into something that's very, very laborious and a lot more challenging than you initially thought. And you end up talking to what you think is going to be 3 or 4 people, and then some more information comes out, and then you have to branch it off to talk to maybe a few more people, and then that person you speak to may say, you know what, you might want to talk to this person. I know he or she witnessed this event, and sooner or later you have a situation where you're seeing maybe 10, 12 people. The subject of an investigation is entitled to representation in the investigation. And one thing that we've done in some of our administrative investigations that typically don't fall within the police department or the fire department is Often we'll have a witness who might be intimidated by the process, who might feel that they're not familiar with having to testify or having to be questioned, and they'll want to have a representative with them as well. And typically they'll select somebody from the Employees Association to sit with them, just to kind of get them through the process and help calm their nerves a bit. That's something that we do allow, but in allowance of that, it sometimes does cause the process to get bogged down, because if we're trying to schedule an interview with this witness, and this witness is willing to be interviewed, but they want to have somebody with them, and that person's not available, then that'll have to get rescheduled for the next day or something along those lines. Again, these are all things that do cause the investigative process to sort of get bogged down. Getting through the administrative investigation, typically a report is prepared, and again, that's not an easy thing to do. Even an experienced investigator, after he or she has sat down with 10 or 15 people, the ability to tie all that together and draw some conclusions and make some recommendations, that can be a laborious task in and of itself, and oftentimes that can take quite a bit of time to put the finishing touches on that report. But once the report is complete, that concludes the investigation phase, and if a decision is made to then utilize that information to take disciplinary action against an individual, then that begins a whole new process in this, and that would be the Skelly process. And the Skelly process begins the moment discipline is served upon a particular employee. And even putting together a Skelly letter can be, again, somewhat laborious. It's not the kind of thing that you can sit down and write in a matter of a half an hour. You have to take all the various parts of that investigation and draw a nexus between whatever violations of policy may have occurred, and connect them to some charges, some grounds, our civil service rules, and potential policy violations. The Skelly letter in and of itself is prepared, and we do require those to be reviewed and initialed by both the Human Resources Department as well as the City Attorney's Office. Once that is complete, everyone's approved of it, the Skelly letter is then served to that employee. And the Skelly letter, as you know, is a proposed action if it involves, as I said earlier, a termination, serious level of discipline. It's very likely that an employee will remain on administrative leave during that period of time. Many organizations handle their Skelly predetermination hearing process in different manners. In the city of Glendale, we enable the appellants really 2 bites of the apple prior to the discipline being imposed. They can meet with their department head and discuss the case with them, and following that, they can also meet with our assistant city manager or her designee, which would be the final step in the pre-disciplinary hearing phase. And again, the meeting with both the department head and the assistant city manager, sometimes that creates some delays in the process. You have to first of all set up the meeting with very busy people, and oftentimes you want to make sure that the appellant has their representative with them. And if we're talking about a member of the association, typically those types of representatives are available. They're here in the workplace. But if that individual is represented by counsel, let's say Mr. Chenet or one of the labor attorneys, their calendars are very booked, and oftentimes, as much as we'd like to see that process sped up, and I know Ms. Beers and the other department heads try to schedule these predetermination meetings as quickly as possible, but as much as they try to push that process along, oftentimes the representative will just not be available for a week or 2 or even longer than that, just given their busy calendar. But essentially, again, in the predetermination hearing phase, the department head and the city manager's office. They do have the ability to modify the proposed action, to revoke it, or to uphold it. And it's a responsibility that they all take very seriously. They don't just go through the motions. They do listen to the employee. They listen to the representative. Oftentimes, I know Ms. Beers does this, and I know her predecessor, Mr. McFall, would want to talk to additional witnesses and other people involved, just to make ultimately sure that whatever action is being proposed is going to be appropriate given the situation at hand. Ultimately, when this process is completed, and the last real step in the predetermination hearing phase is when the city manager's office makes their determination. And once that determination is made, that ends that process. And an individual who is on administrative leave is then either returned to work if there's a situation where no discipline is appropriate, or the discipline's been modified or eliminated, or if it's being upheld, the individual is then terminated, and at that point the administrative leave comes to an end. And that begins kind of the next phase of the process. But the administrative leave then ends at that point, and the employee is either subject to that disciplinary action or they're returned to work. So, again, that was a sort of a brief look at why the process does drag on for so long. And I will say we do our level best at all levels of the organization to make sure each of those steps are handled in a timely manner, but there are just certain things beyond your control, and most of it has to do with just assuring that employees' rights are protected, in that every step that they're afforded in the predetermination hearing phase, that they're given those rights, the rights to representation, the right to be heard by those within the chain of command, are protected. A couple other things I wanted to mention before we wrap this up is, again, according to the rules, the administrative leave could be set forth for 30 calendar days, and obviously that can and does get extended as need be, and that is generally acknowledged by both my department as well as the city manager's office is consulted when these cases do end up taking very long. The question came up last month when this topic was first addressed: how many employees do we typically have on administrative leave at any one time? And obviously that number fluctuates. Currently, we have 4 individuals, and the report indicates the departments that those employees work for, and 2 of them are in police. 1 is in the library department. 1 is in public works. One of these is going to end as of Monday, so that will reduce our number of employees on administrative leave down to 3. But again, this fluctuates. When Commissioner Gazarian first asked the question back in January 11th, we had 5 at that time. And since that occurred, one has been subject to termination. The other has been brought back to work and is working in a different capacity. The last section of the report talks about a potential role for the Commission, about whether the Commission should be involved in discussion of administrative leave, and particularly the extension of admin leave. And I will say, while I generally defer to the Commission if it does want to add some type of additional oversight or review, in this case, it's not something that I would recommend, and the reasons for that are set forth in the report. First of all, the decision to investigate and impose discipline is confidential, and for this to be brought before the Commission really prior to a decision having been made about a proposed action would be somewhat premature. And while I suppose an argument could be made that we can put this under closed session in public employee discipline, I think the more pertinent reason why this wouldn't be appropriate would be for the whole idea that this commission does serve as the appellant body for disciplinary appeal cases, and to have the commission involved in any discussion of a disciplinary case prior to even a Skelly being served or a conclusion being drawn from an investigation could create a conflict of interest and potentially taint that case if it should come back before the commission and they want to hear it. And you all know, when you're hearing a case, that case has to be based upon, as Mr. Potter says, the four corners of the case involving charges and grounds. And again, for any information to come out prior to the Skelly even being served, I just can't think of any practical way of having any type of meaningful dialogue relating to why an employee should not be on administrative leave, without somehow getting into the merits of that case. And I think it's sort of a fine line that would be best for the commission to not be involved with that case. In addition to that, again, the decision to place an employee on administrative leave is often one that needs to be made in a timely manner, and particularly if we're talking about an egregious case involving someone being terminated, or mentioned earlier, sexual harassment, violence in the workplace, that the department head needs to have the ability to act in a timely manner and place someone on administrative leave. The commission meets twice a month, and it may not be practical to have an item brought before the commission before that decision is actually made. So that pretty much concludes the report. And again, I do appreciate the question being asked, and it was very thought provoking. And as I said earlier, while I expected this to be a very brief report, as you can see, there are quite a few elements in the whole subject. But suffice it to say, the decision to place someone on administrative leave is not made lightly. The rules state that it's made by the appointing authority, which is the department head. But I will say that decision is always made in consultation with my office, and I'll be completely honest with you. We get many requests to place employees on administrative leave for a variety of reasons that don't merit either placement on administrative leave as a practical matter or meeting the requirements as addressed in Rule 10. Occasionally a department will say, this employee is really acting unusual, and can't we just put them on administrative leave and deal with them some other way? And typically we will say no. It's not a process to be abused. It's not a process to get people out of the way who we don't want to be here. It's really a process that's designed to serve a need, and again, that need is typically to investigate cases of serious misconduct, and again, to enable that process to go through unabated, and then when that process is done, we either make the determination to return them back to work or take further steps. But with that, I want to again thank you for the opportunity to address this, and certainly if you have questions, I'd be happy to answer them. And
Okay, I think what I'd like to do, first of all, fantastic report. I think really got to the bottom of the issue there, and we appreciate the time and effort you put into that, Mr. Doyle. I want to thank Commissioner Gazarian also for asking the question, because it was very thought-provoking, and we appreciate that. Before we get into questions from the commissioners, I'd like to ask if Chief DePompa or Captain Stokes or Ms. Beers have anything they'd like to add. We may be asking you questions, but is there anything that the three of you would like to add or bring to our attention that Mr. Doyle may not have covered or you think is important for us to know? I see three heads shaking no, so with that, okay.
Covered it all.
If I may.
Okay, Mr. Gazarian.
I too want to echo the chair of this commission's sentiments. I am thoroughly satisfied with the comprehensive nature of the report, and I want to personally thank you. I know my fellow commissioners feel the same way. It's wonderfully put together and very informative. I have what I try and make brief questions, and I have 3 comments. Question number 1 is, with respect to page 2, when we're discussing why administrative leave is provided with pay, I posed the question rhetorically, can we then go back, assuming an employee, a civil service employee, is found culpable for some wrongdoing, can we then go back and seek recovery of the amounts of monies that the city has paid while this employee's culpability was being determined, only to find out that, in fact, that employee was truly culpable to such an extent, perhaps, that doesn't only merit perhaps a reassignment or perhaps a demotion, but rather a termination. In that instance, I wonder what the thought process, I haven't done any research about whether or not that would be legal or not. Obviously, we don't want to break the law. It appears to me that at the very least, if we cannot force or compel a wrongdoer civil service employee to pay back the city the amounts of money that we will have then, in my opinion, wasted on that employee while he or she sits at home, I would think that perhaps maybe there is a provision, or ought to be a provision, that we ought to contemplate in the future, consistent with the law, that would impose upon the wrongdoer civil service employee the obligation to pay the costs of investigation, if nothing. That's a question mixed in with comment. I'm not really looking for any insight, but it's something that, I would like to put out there.
If I could,
Sure.
I'm certainly not aware of any right that we would have to go and collect or to seek a remuneration for the amount of time someone's been placed on leave if they've been found guilty of this. My sense is that that would be a deprivation of their Skelly rights, because they have all the rights up until the time of the imposition of the discipline. Prior to that, again, they've not been proven guilty of anything. Preponderance of evidence.
And I agree with you, because by placing one at home administratively, we are depriving that person of the opportunity to seek employment elsewhere. So I suspect that there is no remedy to seek recovery of monies paid out that we haven't received the benefit of the services. But certainly with respect to cost of investigation, perhaps it's something that the city can contemplate making it as a policy with respect to particular departments that serve the city, if a culpable party. I do know that we now, in the city of Glendale, in the police department, we ask people who are accused of crime and arrested to pay the cost of booking if they are found guilty. And if we're to do that to the citizens of our city, I think we can do that to the employees if they are found culpable. I'll leave it at that. If I may briefly, when we talked about, when you addressed the extension of time of 30 days with the approval from the city manager, and in the paragraph that addresses that, I believe on page 5, it also states that throughout this process, Human Resources and the city manager's office are consulted on the need for extensions to administrative leave. My question is, the approval from the city manager and the consultations on the need for extensions to administrative leave, are they done in writing or orally? And the reason I ask is because I'm a strong believer that if it's good enough to talk about it, it's good enough to write about it. And should one person in City Hall give its acquiescence to an extension of time to a department head, and thereafter that City Hall person is no longer in City Hall, unavailable, incapacitated, we are left with a department head who doesn't have a way of perhaps corroborating that extension that was actually blessed by City Hall.
Commissioner Gazarian, that's an excellent question, and I do have to admit this is not always handled in writing, and it probably should. As I put, it's done in consultation with certainly my department and the city manager's office. But as far as a formal process, no, we've not done that. So that's probably something that we would want to improve in this process.
Thank you. And with my last question, and I'll make my couple of concluding comments. The last question I have is, you state with respect to the role of the Commission that there would be no practical way for the Commission to discuss and ultimately rule on an administrative leave decision without some discussion of the potential merits of the allegations and any proposed disciplinary action. Dare I say that I disagree in the following setting. I am not interested as a commissioner or as a member of this commission to take part in the investigative process whatsoever. When we liken the commission to an appellate body who is the location, the venue of last resort before a conceptually or perceptually aggrieved civil service employee opts to seek court intervention, then we are really saying that much like in the court processes of our system of justice, when there is a need to seek intervention to ensure compliance with procedure, we take peremptory writs. We seek peremptory writs from appellate levels to compel a lower court, to draw the parallel, to follow procedure. Here I don't know that we can effectuate such a thing because there is really no lower body. There is a department head. There are city hall departments, yours and others, that are being consulted. And my concern is, for example, perhaps alleviated when some of these extensions are actually memorialized in writing, the extension of time. We then, as a city, adhere to the employees' rights of having the 30-day rule and then the extensions thereafter. At the same time, we also reduce any culpability that the city may hopefully not face, but perhaps would face, with respect to the terminology that I have come to know now, the POBR, FOBR rights may or may not having been violated. So to come full circle and to tie it into the comments, in the role of the Commission, I did not seek to have the Commission to be involved in the process of placing or extending administrative leave assignments. That is, if that is how it came out, that was not my intention at all, because that would be interfering with the merits or lack thereof, and it would then put us in a position as a hearing body that is really tainted, prior to the matter coming before it. As far as the confidentiality of the process and the concern that you articulated, that would also be a cause for the Commission not to really take an active role, I just want to say that the confidentiality, if you will, is a privilege that the holder of which is the civil service employee, and when we evaluate, or your department from here on forward decides to evaluate, if at all, such a process, the holder of the privilege is always free to waive the privilege, and if they so choose to waive it to seek redress for what some perceived wrong or of error in compliance with procedure, I suppose that could take place only with their blessing and not otherwise. I think my last comment, and I thank you for your patience, you have posed a rhetorical question: should the Commission desire periodic information on administrative leave cases without names or some other form of regular report, etc.? I believe that there are certain reports being brought before this commission, other reports being brought before City Council, on a periodic basis, quarterly perhaps, or some regular basis. I think it would be beneficial, it would be informative, and it would be healthy to have quarterly reports such as this, this is very, very encouraging to have only a total of 4 civil service employees. 1,728 last time I checked that are on admin leave, and to know 3 months from now that there's maybe 4 or 5 or 10 or 2, that's wonderful, because that alleviates the darkness that I was under in January, only hearing rumors in the city that every other person is on admin leave, and not so, apparently. And with that, I want to really, truly thank you, and thank everybody else, including the Chief and Captain Stokes, and everybody else who has participated in this venture with you. Thank you.
Thank you.
Okay, Mr. Manoukian, did you have a...
Yes, I have a couple of comments and a couple of questions. First of all, thank you very much for the report. I agree, it was a very good report. When Commissioner Gazarian requested this item, I also wanted to get clarification. I think, first of all, my look at this, wanted to understand that the process was not necessarily directed at one given department. It was more and more what I think was happening is we would get approached, at least I would get approached by certain employees asking questions about this process, and I really did not know until today exactly how this process worked. First of all, I do agree 100% that this commission should not get involved whatsoever in any way on any of these, because of the fact that we might end up hearing the cases, so I do agree with you on that, and honestly, 4 employees out of 1,700 employees, it's nothing. And I think there's a lot of rumors or misconception out there that we have X number of employees, and that's not the case. And I think this process itself it's encouraging to know at least there is a process. It's not just a department deciding to put someone on leave, but from what you're telling us, you guys HR is kept in the loop.
Absolutely.
And as far as I'm concerned, there's no other reason for us to get involved. And I completely understand on some of these cases why it would take so long. When you have situations of the investigation carrying on for such a long time. But other than that, I thank you for the report, and it's very informative, and it's something that we should not get involved with, other than if your point, Commissioner Gazarian, of at least once every 6 months or whatever, to come back and say, okay, we have X number of employees on leave. That way, if that number ever skyrockets to 30, 40, then we know there's something there that maybe, even then we should not get involved, but it would be something for us to give at least a request for you to get further involved into that situation. Other than that, I have no further questions. Thank you.
Okay, thank you. Mr.
No, thank you very much.
Okay.
Yes, all the questions.
Well, I certainly agree with the comments made by Commissioner Manoukian, and whether or not we get quarterly or every 6 months or yearly reports on the number of people on administrative leave, really, I think if the Commission wants that, we can ask for it, but I really don't see the importance of it based on, right now, the very small number of people involved. I don't see a problem, quite frankly. I do have one question on terms of monitoring employees that are on administrative leave. I've talked with various employees that have been on or were on administrative leave, and I got the impression that it was like a vacation. And Mr. Doyle, during your comments, you mentioned that the department heads have the ability to assign work or expect some sort of return for the money they're getting paid. And I was just wondering whether there's any monitoring set up either by HR or by the department itself to check on the employees, make sure they're at home, make sure they're not in Hawaii or wherever. And so I wonder if you could comment on that.
Yes, Chair Devine, that's a good question, and I have to say, we're really not in the business of, of that level of monitoring. There are occasional calls to the employees, certainly, and work-related things as well as questions they may have, or to some degree assignments. But for the most part, we don't have anyone visiting the home or anything like that. The employees are told when placed on administrative leave. In fact, that's probably something I could have included in this report, is a sample letter, because they're told that during the regular work hours they're assigned to their home and they're to remain in that on the premises for the duration of their regular work hours. And if they do want to take time off, if they have a doctor's appointment, they would be required to utilize sick leave, or if they want to take a day off to go to the beach or whatever, then they'd be required to call in and utilize vacation, and that would be a different bank of leaves that would be charged against the employee. But outside of that, it is largely the honor system, and I can tell you, if it's determined that someone who is on administrative leave has violated that order, then they would be subject to further disciplinary action, and we've had several cases of that having occurred. Someone who's being terminated or someone who's being demoted. We would then consider serving them with a new Skelly with additional charges and grounds on it if they have in fact violated that ordered leave. So I don't know if that answers your question.
Okay. I'd like to ask either Ms. Beers or the Chief, in your experience when you've placed people on administrative leave, whether in fact the department does utilize them, give them assignments, research or whatever to help the department while they're gone.
Mr. Chair, members of Commission, good evening. That is something that we routinely do, especially if the individual is of a supervisory rank where they're responsible for doing performance evaluations. Those will be assigned and completed while the individual is on administrative leave. And as Mr. Doyle pointed out, they are assigned to their home. That's an administrative assignment between the hours of 8 and 5. We do monitor that at the police department. We are requiring that if they deviate from that assignment, they have to take leave time as indicated, and that's approved by the Bureau Commander of Professional Standards Bureau. So it is regulated fairly closely in our operation, and they are, where feasible, certain administrative assignments will be allowed to occur while they're on administrative leave.
Thank you. That answers my question. Any other questions?
No, thank you.
Is this a note and file item, Mr. Doyle?
Yes.
Okay. Oh, I'm sorry, Mr.
No,
McKeon.
not, Chairman, I wanted to, just to follow up on the comment that I had made. I'd really be interested if, at a future date, if we can get a presentation on the details of Police Officer Bill of Rights and also for the fire department, so we can get a better understanding of all those rights. I don't know if my fellow commissioners would be interested in something like that. I would be.
Gregorian, would that be something you'd like to see?
I would like to see if you have something in writing that we can refer to, because presentation is nice and public would be able to benefit from that. But in the meantime, something in writing, some brochure or something, a booklet, that because I know majority of our hearings we encounter to this point that POBAR violation of POBAR ward, so Bill of Rights of Employees. But again, that's part of the closed session hearings. So
It's public information.
It is public, yeah. But during the POBAR, yeah.
It's
Okay,
not
I think
something-
I'll make an executive decision, and yes, we would like to have a report on
Yes.
that at your earliest convenience.
Mr. Chair, I'd be happy to do so.
Okay. Let's thank-
POBAR has been around since the 70s. FOBAR is relatively new. I think the law was
Especially now,
passed in 2009, I believe. And it's similar to POBAR, but little distinctions, little differences. So we'd be happy to do a report.
We'll move on to the next item. I want to thank the Chief and Captain Stokes and Ms. Mears for coming in and assisting us. Thank you very much. Okay, we'll go back to our regular agenda. And the next item, please.
Oral communications.
I have no cards. Is there anyone in the audience that wishes to address the Commission on items not on the agenda? Seeing none, we will move on to the next item.
Eligible list established.
Mr. Doyle.
Mr. Chair, we have one eligible list that had been established since our last meeting. This would be the Community Services Supervisor in our Community Services and Parks Department. As you can see, this was a promotional exam, so our number of applicants was only 7, and following the process, we have 3 who made the eligible list. So with that, this is a note and file report.
Any questions?
Nope.
Okay. Next item, please.
12-month probationary period resolution.
Mr. Doyle.
Mr. Chair, members of the Commission, as you are aware, the Commission has the authority to approve resolutions establishing the 12-month probationary period for our employees. Most of our positions citywide have a 6-month probationary period, but typically our management level positions, our sworn police and fire positions, carry a 12-month probation. We do have other positions in the non-management ranks that carry a 12-month probationary position. Just back in December, this resolution was brought before you along with several other resolutions that we bring to you on a periodic basis. And since that time, we have established a new classification, both by approval of the City Council and the Commission as well. And what we wanted to do was ensure that that position was included on our resolution relating to 12 months. And that's the Employee Health Coordinator position that was, again, established by Council last month. And I think the Commission approved this specification for this position at a few meetings ago. Again, we've updated this resolution to reflect that one change. I think it's on page 3 of the resolution. You can see it's underlined. This is a non-management position, but we feel that given the level of importance that it carries within our office, that it should be on a 12-month probationary period. And I do recall some of the commissioners in making inquiries about the educational backgrounds and things like that. And we certainly want to hold the individual who gets appointed to this to those requirements. And we feel that 12 months would enable us to perform that easier than a 6-month. So with that, if you have any questions.
Okay. Our city attorney has pointed out that this is a public hearing item, so at this point I will open it for a public hearing. Does anybody wish to address the Commission on this particular item? I have no cards. Seeing none, we will close the public hearing and ask if there's a motion.
Move to approve.
Second.
Okay. Any objections? We have unanimous consent on that one. And we have the next item, please.
Agenda forecast.
Mr. Chair, this is our agenda forecast. As you well know, your workload has been very busy with hearings, and again, a lot of that is done behind the scenes because most of these are closed hearings, but we do have hearings set for the next several meetings, some of which are occurring on the same days as our regular meetings. So we'll try our best to do our regular business along with working around all those hearings that we currently have. I do want to point out at our next meeting on March 14th, we already have a few items for the agenda, and we anticipate having an appeal on a background investigation. And so that item will be set for March 14th. That will be a closed session item as well. Other than that, you can see the next few meetings, the various items that we have on your report. If you have any questions, be happy to try and answer them.
Okay, on one of these, we'll add in the item that Mr. Manukian requested, the report on POBAR and FOBAR. Okay.
Yes. Again, I can envision completing that sometime, maybe at the one of the April meetings, something like
That's
that.
fine, thank you.
Okay.
Any questions on the agenda forecast? Seeing none, we will move on to the next item.
Reports and information, past due employee performance evaluations.
Okay, I think I'll ask Mr. Manukian if you'll
Yes.
kindly go through
I'll-
that for us, since you're the expert in it now.
Yeah, I'll pretend to be Mr. Gantis. Okay. We have, let's see, first notices. Well, city management has none. City treasurer's office has none. Let me see who else. Fire has none with 207 employees. Great job, Chief. Library has none. The police department, 353 employees, 0. Good job. First notices. We have city attorney's office. And we have community development. We have 2 first notices. Actually, I meant to ask, when there's a number underneath, why is that separated under when you have a 2 and a 1? Because of the size of the department?
No. Commissioner Manukian, the numbers at the various levels are when those evaluations were due.
Oh, I see.
So with, like, the one, I don't know which one you're looking at, community.
Community development?
Community
There's
development.
2 first notices, and then right underneath, there's another 1.
Two of them were due on December 16th. One was due on December 17th.
Okay. Then we also have community services with 2 first notices. Finance with 37 employees has 4 first notices. Actually, 5. Glendale Water and Power has 1. And Information Services has 2 and 4. And Public Works has 1. And then second notices, we have Community Services and Parks Department, and also for a second I thought it says Human Resources. Wait a minute now.
Your tongue.
It's Information Services has 2 second notices, and we have no third notices. That's great.
Okay, thank you very much.
Thank you.
Let me ask a question.
Yes.
Can you explain to me what's the significance of special circumstance evaluation versus no special circumstance? For example, in Community Development Department, it says 1 special circumstance evaluation. With Information Services, it says 1 special circumstances evaluation. Then with the police, though there are none, underneath it says 6 special circumstances. I don't know what those mean.
Sir, Commissioner Gazarian, the special circumstances is a separate category of evaluations that, for all intents and purposes, I don't want to say they're late, but they have not been able to be served for really one of either 2 reasons. One, you may have an employee out on either some form of long-term leave or disability or workers' compensation or something like that, to where they can't be served, or in cases where, as we were discussing earlier, someone's on admin leave or under investigation for disciplinary action or something along those lines, where the evaluation is being put on hold in order to determine whether or not those items under investigation need to be included in the evaluation. So all that means is that they were unable to be served due to special circumstances.
Thank you.
Following up on that, I was wondering, is there any time limit on the special circumstance evaluations? For example, if someone is under investigation, can they possibly have no evaluation for 1 or 2 years, or would that be excessive?
I suppose theoretically that's possible, but you're typically not going to see an investigation go on for that long a period of time. I have staff that continually monitors this with each department every single month. You've met many of my staff, Ms. Mallon, Ms. Jagaspanian. One of their very, very key responsibilities. And each and every one of these, including the special circumstances, they get a notice each month asking, where is this evaluation? And they've almost become pests, but it's what we do. And those departments have to justify each month the special circumstances category, and I have to approve those. And so if a department has a special request, and once again, like I mentioned before, departments will try and ask, Matt, can we put this person on special circumstances? I'm not quite ready to serve the evaluation, and I need to find more information. And typically, I'll say no unless there's something really serious going on, a disciplinary investigation, or of course, the person's out on some form of leave or on workers' comp leave or something like that. So it's another area where, again, my department has to more or less be pretty judicious in applying that.
Thank you very much. Any other questions on this item? Seeing none, we'll go to the next item, please.
Civil Service Commission and staff comments.
Mr. Doyle.
Mr. Chair, I do want to make a brief comment, and I see Phil Lanzafame out there and our employee association representatives. As you have all heard, our redevelopment agency has been effectively collapsed by the actions of the state legislature and our governor. That action was, quite frankly, devastating to this organization, and the various groups that supported redevelopment filed a legal challenge to those actions. The item went to the Supreme Court, and just prior to the new year, the California State Supreme Court upheld the dissolution of the redevelopment agency and the funding that cities like Glendale receive thereof. So we're now in a very difficult state as far as our functions, the services that have been handled by our redevelopment agency and our community development department in general. What we've been doing is hoping and working very hard behind the scenes to see what can be done to ensure that some semblance of redevelopment is preserved, and that the functions that they serve are able to continue, at least in some format, throughout the organization. But outside of that, the very real possibility does exist where we may be looking at layoffs of substantial numbers of our employees, simply because we have approximately 40 employees that are funded directly by redevelopment monies. In order to sort of work behind the scenes to prepare for what could be a worst-case scenario, we've been working with our various employee associations as well as the various department heads throughout the city to try to identify vacant positions elsewhere in the organization that exist, and to put into place some system, and I'll call it sort of an accelerated hire/transfer process, which would be fully in compliance with our rules, to try and see as many of these employees that we could place elsewhere in the organization so as to avoid layoffs as much as possible. And again, we've been working very much behind the scenes. The various department heads have been really, really open, really receptive, and really good about thinking about this initiative. And I just wanted to share with the Commission that this process is in place, and what we're hoping to do, again, is fully in compliance with the rules, but it will, and they require a little bit of creativity, a little bit of flexibility as far as placing people in positions that their qualifications may be a little off and may not exactly fit in, but we're doing everything we can to really work behind the scenes to preserve positions in the organization. It's something I wanted to make the commission aware of, and again, should you want further information on this, I'd be happy to discuss it both here or in the future meetings. So.
Mr. Doyle, what you just said, I mean, in the past 20, 25 years, I've had the opportunity to work with a number of individuals from the redevelopment agency, and I can tell you they are one of the best assets that this city has. To lose a single one of these employees would be an absolute, it's just mind-boggling to think that we're going to even possibly lose one, because I think every single one of them has such a wealth of knowledge, I worked with a lot of different redevelopment agencies due to my career, and I can tell you, and I'm not just saying this because it's my city, it's the employees there are the absolute best that we have, and I'd be sad to hear if we even lose one, let alone 40.
Appreciate that.
Are we essentially trying to reassign those valuable individuals who are apparently assets to the city? Are we reassigning them? And you mentioned that they're perhaps not exactly qualified, but can we provide retraining so that they are exactly qualified, and then hold them in abeyance in the hopes that the state will change course and we will reinvent our redevelopment agency and we'll have everybody in place?
Yes, that's the idea.
Guzarian, Ms. Barpetian has a comment.
Mr. Chair, members of the Commission, this item is not on the agenda, and my concern is that that we may go deeper into the discussion than we can be allowed by the Brown Act. So if you do have additional questions and you'd like to address them to Mr. Doyle, you may do so tomorrow privately, or if there's general interest on the part of the Commission, then we can certainly agendize it for a future meeting.
Very well. I agree very well. I would like to see if it agendas, because I do have so many questions. So it's not fair to ask these questions. Yeah.
We should agendize it and maybe have it come back and
We'll ask Mr. Doyle to agendize it.
Certainly can.
Yes, that'd be great.
It's something that's very important to all of us, I think.
And when you do, Mr. Lanzafame, if you could be here, because I do have some questions also. So, pardon me?
I will be here.
Okay, thank you.
We'll come and find you.
Okay, any other comments from the staff, from commissioners, from our city attorney? Seeing none, we'll move on to the next item, please.
Closed session, public employee appointment.
Okay, at this point, we're going to go into closed session. We will be reporting out in order to adjourn. So at this point, anybody that's not associated or connected with a closed session item, we'll ask you to say good night.